Hello, ladies and gentlemen. Welcome to a March 9th, 2023 edition of the MSP Initiative live. Not in Orlando this time. Last session, we were actually live at the Channel Company event down in Orlando. Back in the normal same bat time, same bat channel situation. We'll do some quick housekeeping and then we'll get into it a little bit. So mspinitiative.com, this and every other session we've ever done is recorded, and we put it up here under sessions on mspinitiative.com, so you can go and listen to it or watch it, whatever is best for you. But if you're driving, listen to it. We have our, infamous, I call them infamous, but they're famous, community block parties. They are progressing, I promise. I'm going to keep, reminding you about these until we formally announce one of that. But one is actually coming up, since we're very time-based, in London in a couple of weeks. But yes, we're going international this year. It's kind of exciting. So stay tuned for that. Of course, we have our MSP Community Minds events. We are going to change the date on the first one. The second one's still solid in Denver, August 14th to 15th. We're going to be moving our first one to a new set of dates. Give us more time to get it together. But we're basically bringing other industry specialists from around MSP land. They're going to come in and we're going to do workshops with you rather than just PowerPointing you to death, because how many breakout sessions have you ever been to that you didn't do anything about because you wrote notes and then you lost those notes or you just didn't have time? Well, now we're going to progress past that. And then lastly is our community offers. There's more coming. There's 3 listed, but basically just community offers from other companies around the industry that are looking to give you some special promos. So all that being said, those are all the housekeeping, quick and easy, 1 minute worth of things out there. Today's special guest, Rob Scott, who was referred by somebody over in ConnectWise land, which is great. We love, cool people from, different views and different understandings of what's going on out in the industry. So Rob, for people who have never seen you, talked to you, heard about you before, why don't you just give us a little bit of background on yourself?
I'm a lawyer that practices in a small law firm called Scott & Scott, and we do computer law. And so as a result, we've been in the managed services space for almost 2 decades, and we represent over 300 MSPs, largely in connection with customer contracting services. But we also offer a variety of other services to MSPs, including litigation and intellectual property and M&A services as well.
Awesome. Well, there's a lot of that. All of that is all happening. So let's be honest. Let me throw you a couple of easy ones. Let's be honest. Copying somebody else's service contract or agreement, and who knows where they got it from, pretty popular. It's pretty popular in the MSP space. Quite frankly, just, I guess, hey, you may have somebody on the hook, and then, actually I heard somebody went to ChatGPT the other month and thought that they could generate a contract from ChatGPT. That wasn't a good idea either. But I don't know. I feel like a couple of things. One, service contracts you would think are pretty straightforward. You should have one and you should make sure they're legitimate and actually protect you. But 2, short of copying somebody else's, and who knows where they got it from, if you haven't had it looked at recently, things change. Like if your service agreement's from more than 3 years ago, probably not in a good place. So I feel like these 2 things kind of converge in a vortex of problems for people who provide computer or IT services. And I just don't understand, other than maybe they just don't want to spend the money, but I kind of feel like that's penny wise, dollar foolish. If you don't spend the money now, I promise you're going to spend it later, and it's going to be way more expensive. So I'm sure you've seen this at scale because this is what you do. Maybe you can give us some ideas and maybe the worst scenarios, but what, when you run into this, I'm sure you just basically go to the shredder and then start from scratch. Tell us why you think this is happening and what the bad results of this ultimately lead to.
Well, I think there's an access problem to specialized attorneys. There's not that many firms that focus in computer law, and still fewer that have industry expertise in managed services. And it's expensive to hire a lawyer. It costs a lot of money. If you're a startup or, you're just, trying to grow your business, you could think of a lot of other things that you'd rather spend the money on. And so I've been working very hard to deliver affordable legal solutions to MSPs, including those that are, under $1 million in revenue, because I think that's the group that needs the most help. They're the most likely to be underserved. And that's why the solution that we've recently developed, which is a cloud-based solution for contracts as a service for MSPs, is really my way of trying to solve the legal services gap for the lower end of the market. The high end of the market, owned by private equity firms, got cadres of lawyers that work in-house and many large law firms on Rolodex. They have agreements. It's really the small and medium-sized firms that don't. And then the other thing that we're doing is we're delivering our legal services in a manner that is different than what I did before, which is using emails and word processors to deliver the solution, which when I delivered those contracts, they became stale and increasingly stale. And to your point, in managed services today, there are so many things that are changing rapidly, including the threat landscape, issues regarding risk and cyber risk, as well as pressure from underwriters and clients and regulators, and the explosion in laws that affect MSPs, both internationally at the federal level and increasingly at the state level. It really is amenable to an as-a-service offering. And what we're doing in the cloud is just a logical extension of what we tried to do to bring our clients online for contracting. And so once we moved our clients to online, it was a logical next step to go to a cloud-based solution where we now host the agreements and keep them updated as a service for our MSP clients.
So how does that work though, right? If the agreement, let's say some new law comes out tomorrow, and we hear CISA guidance changing.
Take Virginia's privacy law, which is a recent law, okay?
Okay.
And so the way our system works is, as part of our setup, we help each MSP develop a data processing agreement that covers all of the regulations that their clients are subject to, and by extension that apply to them. And as part of that service, they can enroll in a certain number of states, or many of our clients enroll in all states. And what that does is we keep track of the legal developments. And when a new state law comes online, we update their data processing agreement and send them a note that their data processing agreement's been updated.
Now, does it's set up in such a way where the end customer's notified? Do they have to actually accept the agreement, or is it written in such a way where it's just, hey, there's now a change, go here, and if you don't like it, then do something different?
That's one of the things that's beautiful about our solution, is we allow the MSPs to put all of their customers on the same contract form. And the way that we do that is exactly as you described. When they sign originally, they agree that the provider, in this case the MSP, may update the terms and conditions and give them notice of those updates by posting those changes to their website. And also, as part of our service, when we make the changes, we draft an email notice for the MSP to send, if they like, to their customer. And you see it every day, right? In your inbox, Dropbox, we updated our terms. Adobe, we updated our terms, right? And so it's been used very successfully in the enterprise. And what we're doing is bringing enterprise class contracting solutions to small, medium, and large MSPs.
That's awesome. So effectively, by following that same track, if you ever get into a situation where you have to go to litigation, which, let's be honest, we want to prevent that, right? That's the whole point of doing the work now instead of later. You can, it will hold up saying, hey, listen, there was a change. We posted the change. They were notified. They could always go back and reference the current version. We have a tracking of when they were notified. So their option at that point would have been to either opt out at that point if they didn't agree, or just continue using the service.
Yeah, and then the language, to your point, says if you continue to use the service, in addition to getting notice, if you continue to use the service, you agree to the new terms. And there's a chance that a court could say, you know, we're going to make you stick to the original. But the probability that the case turns on the change is very low.
Okay.
Our basic structure for indemnity, limitation of liability, and insurance, which are the core risk balancing provisions in our agreements, they haven't changed that much in 5 or 6 years.
Okay.
It's more of the ancillary, the regulatory compliance pieces, and the exceptions. So, for example, 2 of our most recent critical updates were after the Kaseya incident. We developed a schedule of third-party service providers, which is a list of every solution that the MSP is bringing to the client. It contains a description of how that service is being used, a link to the agreement that will apply, and a link to that vendor's privacy policy. And in bold letters at the top, it says, client agrees that under no circumstances will MSP be responsible for an act or omission of a third-party service. And they agree to make any claims related to that against the third party.
Okay.
So we created that in response to the Kaseya incident because I felt like in the wake of that, the agreements that we had written before were not as clear and transparent about the rights that were being given up. And so that's an example of a critical update. And if MSPs don't have that, I think third-party channel provider risk, vendor risk is one of the largest risks to mitigate. And if you haven't taken a look at our schedule of third-party services or an approach that's similar, I think that's probably one of the most important things that MSPs can do. The most recent update that we did is related to MSPs getting involved with helping customers complete applications for underwriting for cyber liability insurance. And there was a recent case brought by the Travelers against the IT company who had a claim related to ransomware that the Travelers denied. And not only did they deny the claim, they brought a lawsuit to terminate the policy on the grounds that the tech company misrepresented the nature of their usage of multi-factor authentication. And I was thinking to myself, what if that was an MSP's client? And that happened to the MSP when the MSP helped with the application. Now you got a client with a claim and an insurance company who's saying, I'm not paying it. What is that client likely to do? And so my kind of approach to critical updates is if I'm losing sleep over it, next quarter, my clients are going to have it in their agreements. And so now all of our clients have an update to their master that says, while they're not obligated to do so, they may from time to time assist with preparing applications or other information for insurance purposes. And it's the client's information. And under no circumstances will the MSP be responsible for any adverse action taken by the carrier in connection with underwriting or claims administration.
Okay.
And so with this platform that we have, we're now able to push these changes at scale. We have over 100 MSPs on this platform. We're able to push all those changes such that by the end of the quarter, everyone's agreements will be updated. And with the old approach that we had with emails and Word documents, we could have never done it. Similarly, many of our clients have links embedded in their quoting tools, like in ConnectWise CPQ or in Autotask or other quoting tools. We deliver our services directly to the client's websites and to their quoting tools. And so when those documents get updated, those smart hyperlinks always point to the live document. So it's administratively much easier for the MSP to manage their agreements and the changes that we're making to keep them updated.
Yeah, it is definitely a modern way to do this because one of the challenges that people have is, just versioning, right? Like let's say every time they go to add a new service, and then they have to like attach the updated version of the agreement, and then now you got to keep track of all of that. I mean, can become problematic if there's constant changes, right? And sometimes it could be just upgrading or downgrade of quantities, right? It could be, like the company's growing or shrinking. But this seems like a much more modern approach to just dealing with things without waiting for a renewal, and dealing with things without waiting for basically a change to occur. You're just basically structuring it in a way where it's like, hey, listen, we're going to be sending changes down on the regular. Here's how you're going to know. And like, I assume that, I guess some MSPs probably lock their customers into terms, right? 2-year, 3-year, 4-year time basis. But, if the customer doesn't like one of your changes, right? Let's say that insurance claim, clause that you added, they read it and they're like, nope, I don't like that. What happens?
It hasn't happened yet, so I don't know, but I would advise an MSP to tell that client, if it was a good client, that we'll lock them into the last agreement.
Okay.
We'll opt them out, right? But we haven't seen that. In fact, what we've heard from our clients is that not only are we streamlining their sales processes and their contracting processes, but customer requested changes has all but disappeared. And the reason I think for that is twofold. One, I think that we've all been trained by large enterprise that if the terms and conditions are online, they're not negotiable. And I think that's a big part of it. The other part of it is the way we do the agreements, everything that's commercial in nature is in the quote or the proposal. And so they're negotiating on that stuff. And by the time the commercial terms are done, the legal terms and conditions are not that big of an important deal to the customer. They figure that, that they're going to be subject to certain terms and conditions. They look at them, they're very long, right? With over 100 MSPs as clients on this platform, I'm getting about 2 requests a month for client changes. And I think I'm seeing a high percentage of them because I include the review as part of maintenance and support. So there's no reason for them not to show it to me, like a financial reason. And so to think about that 100 MSPs and we're getting 2 requests a month, that just shows you how when you approach your contracting as part of your sales process and you move your contracting to online terms and conditions, you're going to see a dramatic increase in the velocity of your quote to cash. And you're going to see a huge decrease in the amount of administrative time you're spending both preparing and presenting agreements and negotiating with clients over those agreements.
So let's talk about the one-offs then, the 2 a month. What kind of requests do you see coming through? Like, what are the customers asking for changes about?
I would say that the most probable place that a client is going to have some pushback is related to those risk balancing provisions that I mentioned, particularly if they're represented by counsel. Then those changes are going to be things like limitation of liability, indemnity, insurance. For example, our agreements require the end users to carry first-party cyber liability insurance. Some of them may not have it. They may not want it, whatever. So those would be things that might come up. You also will see things regarding like effective termination. What happens when we break up? What kind of transition services does the MSP provide? So those would be common, like risk balancing and what happens when we break up are the types of things that lawyers think about.
No, that's fair.
Yeah, when they look at a contract.
So obviously not every MSP of the 100 plus that you have on your platform are using the exact same vendor list, right? I mean, they vary, right? Some people use, SentinelOne for their endpoint security. Some people use, I don't know, CrowdStrike. I don't know. But my point is, like, do you give them the ability to just easily select what the vendors are to update their agreements?
Yeah. So part of our setup, we send the scheduled third-party services, has about 170 vendors on it. And as part of our setup, we ask our new clients to go through and tell us which ones they're not using
Mhm.
and we take those off. And if there are any they are using, then we go out and get the appropriate agreements and populate it. And that becomes their customized schedule of third-party services. And
Mhm.
it's one of the documents in the stack that's updated quarterly.
Okay. So like
Because
the cadence is definitely quarterly though, right? Like if they add a new vendor in January, their update to their agreement may go out in March, but like that, like they'll go
it's
and
actually,
update.
we time it so that that's not the case. It's four
Okay.
times a year. So if
Mhm.
they make a change in the first month of the quarter, we'll update it in the first month of the quarter, and then we'll just catch them next quarter.
Okay.
So we
Got it.
don't, yeah, so it's four times a year for that reason instead of quarterly, because they may make a change early in a quarter and not want to wait a couple of months. But so that's why we do it that way. And then on the schedule of services, right?
Yep.
It's another thing that changes a lot. Like compliance management is a huge opportunity now. I think prompt management for AI is about to be a big thing. And we're going to see emerging managed services around training and managing learnings for AI, for chat, GPT, and other platforms. All these things that are emerging, right? We're keeping track of that. As clients come to us and want to add these things, we add those service descriptions to our template. And then each client that comes on board gets access to our schedule of services, which is our descriptions. And then they use that to customize and turn it into their own document. But this is something that we update quarterly. And, we've added SKUs for virtual CIO, virtual compliance officer. We have business process automation. We have just, life cycle asset management. Anything that could be an IT managed service, we can create a description for it. And then we have service attachments that those descriptions fit into. They're either going to fit into a IT managed services attachment, a cloud and hosting attachment, a backup and disaster recovery attachment, or a managed security services attachment. And so those are the agreements. We also do surveillance and access control, security alarm monitoring. So we have a vast library of both service descriptions and service attachments that ride along with our MSA, all of which reside online and are called to and incorporated by reference by virtue of changes that we make to the MSP's existing sales quotes and proposals.
What about, I don't know, one-offs, project-based stuff, right? Hey, we're, out here, yes, you're agreeing to these reoccurring things, but by the way, maybe we need to do a migration or a implementation or some sort of project-based work in order to get them there.
Project services are described in the quote or proposal and are subject to the master.
Okay.
So the master agreement has all the terms and conditions that are applicable to project work. And in the quote, you say what the project is and what the scope is and so forth. The commercial terms are in the quote. The legal terms reside in the master.
I just had a quote, Rob. I made a question, Rob. If you can post your contact information. I joined a little late. I came off another meeting.
No worries. We'll definitely make sure we get that out there before the end of this.
Great. I appreciate
No worries. Thanks for that. So is there how do you, is this a flat fee kind of subscription based model for your services, or is it based on the number of contracts that are, are active, against the customer base, or how does it work?
We have a number of different licensing models. The most basic model that we have is similar to the Microsoft enterprise structure.
Mm-hmm.
It's a 3-year subscription that results in a perpetual license at the end.
Okay.
And includes both the license and the support as for the first 3 years. So our contracts as a service solution for the base packages, including all the modules that I mentioned to you earlier, is $399 a month, and it's $399 for a one-time setup fee.
Okay.
And then we have other modules that we've added, including we have a policies as a service. So for the MSPs that are subject to regulations like HIPAA or GLBA or others that require things like written information security policy, breach incident response plan, and so forth. We offer those policies as a service to MSPs, and that module is $99 a month.
Cool.
So
So
for under $500, an MSP that is doing business in every state in the country and is subject to, a variety of federal and international laws can subscribe to this service and never have to pay legal fees again to keep their templates updated, or to have initial review of any customer changes. This is intended to be a solution that is an ongoing partnership with quarterly check-ins, and in many ways emulates the business model of the MSP.
I was about to say exactly that. So that's cool. What happens when somebody gets to the point where cooler heads didn't prevail, and now there is a situation where litigation occurs?
So my primary goal in litigation is either to be the plaintiff, i.e., the MSP had a client that didn't pay, and they didn't pay their early termination fee, and they haven't paid their last 3 months, and I want to go file an arbitration and get that money for the MSP.
Mm-hmm.
Anything on the defense side, I'm going to want to make sure is covered by insurance. So that if the MSP is facing a litigation where they're the defendant, my goal is to make sure their E&O covers that. And if it doesn't cover that, then there's a very limited amount of money that the plaintiff can recover, because my limitations of liability says the customer can get either 6 months of the fees that they paid, which is usually, a fraction of the claim, or the proceeds of available insurance. So I think about covered claims and uncovered claims differently. Either way, we'll be there immediately. If they have a case, we get notified. We help them communicate with the carrier to get either counsel assigned or get us approved to defend it. And if it's not going to be covered, we'll defend it for them. And any legal services that subscribers acquire from our firm is at $100 an hour discount. And the litigation of this type would be in the same vein. And in many instances, we do the plaintiff's work to go after MSP's customers for a fixed monthly fee instead of hourly. So,
Okay.
so the goal, my goal number one is make the agreements clear enough to where there's not going to be litigation. And if there is litigation, to make sure that, if at all possible, that litigation will be covered such that a defense will be provided to the MSP.
So how does it work where, like, I don't know where you're physically located, but let's say your MSP customers in a different state and they're going to need somebody.
We litigate cases all over the country.
Okay.
There's, between me and my colleagues, we're admitted in many courts. And in the ones where we're not admitted, every court in the United States has a procedure to apply for admission, what's called pro hac vice, which means for the case. And so what happens is, if we have a case in fill in the blank state, then we just make a motion, make an application to be admitted for that case. And what happens is that, they look, there's a process to, get vetted by the court before they approve that, but it's fairly administrative in nature. And as long as you check all the boxes, I've never had one that wasn't approved.
Awesome. I mean, that was going to be my next question, but the answer is it's never been a problem.
Yeah.
Let me flip directions for you. So you've been doing this for a long time. It seems like. Can you give us I don't need names, but can you give us an example of the nature of some of the cases that you did have to go to litigation for?
Yeah.
I mean, obviously people not paying their bill, that's an obvious one, but like things outside of just, hey, they canceled, they didn't pay their bill, that, what other stuff has bubbled up to the top?
So I would say the biggest areas are around data going missing, and data compromise. So, I had a case where I represented a managed services / cloud provider that was in the tax preparation vertical. So they had a cloud solution for tax preparers. As part of their solution, they were offering backup and disaster recovery. They had a drive array fail. And it threw an alarm. You know, with all these things, there's like a number of different failure points, right? But the long and the short of it is this array had multiple drives fail. We had 3 forensics firms that couldn't retrieve the drives. And 3 of the tax accounting firms lost all of their tax returns. And if you know anything about the way tax preparers work, they start with last year's return and roll it forward. If all of your old returns are gone, you've got a hell of a problem in tax season.
Yeah.
So there were claims that were made. We gave notice to the carrier. The carrier approved my firm to do the defense work. We argued that the tax preparer had an independent obligation under IRS rules to maintain the tax records that they couldn't delegate to us. And if they had complied with that law, they wouldn't have any injury by virtue of the fact that this raid went down. And in addition to that, we had a limitation of liability that limited their recovery to the 6 months of fees that they paid. So ultimately, the carrier paid a little bit more than that, and the cases were settled. But after that, I put into my agreements that the customer has an independent obligation to back up their own files.
Okay.
And I put that in there because how successful this argument was about where the customer has an independent obligation to preserve their, their own backups. If there's a failure, which is probable, I mean, backup is like one of the least predictable and accurate solutions we use, that MSP is not going to be responsible for that. So that's an example. The other example is recently I had a call with an MSP. Their client reported that $1 million was withdrawn from their bank account. And so I was engaged by the MSP to quarterback the investigation into what happened. And the long and short of it is that some threat actors hijacked their mail server, that the principals of the company were using some compromised emails, which allowed the threat actors to take over the email accounts. They were using similar passwords across the network, including in their VoIP solution, which allowed the threat actors to divert calls from the bank, who, when they were trying to call and approve new people being added to the bank account and the actual $1 million transaction, the threat actors rerouted the voice system.
Wow.
So that the bank was actually talking to the threat actors instead of the people at the company. But because they owned all of the email and they were using compromised email and password combinations, they knew the security answers to give to the bank to approve the transaction. So these are the types of things that I'm talking about. And that's why when I talk now to legacy telecom companies, which I do a lot, I tell them security is the new frontier for you. If you compared the way a networking company sets up a mail server or a file server or an application server compared to the way a VoIP company sets up a voice server, you'd be shocked at the lack of security tools that are, deployed.
It's true.
And 10 years ago, I was telling MSPs, you may not like this, but you're in the security business. And the sooner you come to terms with that, the more successful you'll be. And you know what they told me? We don't have the expertise. We can't afford to hire the people with the security, right? And so obviously the vendors have come forward with tools that MSPs can deploy, and a number of different things have changed. But I see the same thing happening with voice. I mean, the fact that they were able to hijack this voice system and move $1 million,
That's the
tells
first
me,
time I've heard that approach,
Yeah.
but I mean, it makes sense, right?
Yeah.
If the bank's gonna say, hey, our SOPs, we need to talk to a human being, they've they're able to reroute the calls. I mean, there it is. It's just like that. But I mean,
that's the other reason why we recommend that our clients have their SIM cards locked.
ah,
Because the other thing that these threat actors are doing is they're hijacking the SIM cards
mhm.
and rerouting calls that way over mobile. So it just like the threat landscape continues to emerge. And that's why it's so important for MSPs to implement risk mitigation strategies that include legal, right, and good contracts, but also the proper insurance and the proper policies and procedures and controls to have good security in the first place.
Now, back to your example, the insurance company of the end customer tries to come after the MSP because, like, I don't know if you're up, like the White House came out, I think last week or the week before, and said, hey, our new CISA guidance is that the responsibility of network security falls on the service provider, not on the end customer. And I'm like, that's, it's interesting how CISA and that whole department keeps on pushing back on MSPs. I digress. But like, I'm sure the insurance companies are going to follow that if they're not already. I think they're already, meaning like they keep on trying to force the liability onto the service provider as much as possible. Do they fight, those clauses in the, I'm sure they try, but do they can't, or do they successfully litigate the fact that, maybe that contract isn't fair, or if the court, would say, no, that even though they agree to that, that's not, like it's kind of on the service provider.
That was the argument. That was the argument that was made in the tax case. They acknowledged that the agreement said that they can only recover for 6 months of fees, but they argued that that was against public policy. I think it was a losing argument, but what argument were they going to make? I mean, the contract was as clear as it could be. So I think the bigger concern for MSPs in this climate of like shifting responsibility is that the insurance markets are becoming leery of the aggregated risk that's presented by MSPs. My opinion is it's a misguided view, because take those same 100 accounts that the MSP is working for. If the carrier had those 100 clients, they'd be a much higher risk to that carrier than the fact that the MSP is taking care of them. So I don't agree with it 100%, but it's a reality that MSPs need to really understand. And I think the MSPs that are able to keep their insurance costs down and stay insured, which is increasingly becoming an issue, are going to be at a competitive advantage over those that are having trouble maintaining insurance or are seeing that their premiums are getting jacked up like crazy.
We usually have a guy that pops on named Keith from California that says that, he's been involved in some cases as an expert witness where the court felt that the argument against the MSP as a defendant was that they misrepresented themselves, right? Like on their website or on their marketing paper, documentation, they claim that they do this, this, and this, but maybe that wasn't done.
That your network will be safe.
Yeah.
Yeah.
I mean, like he's saying that holds, like that's a valid argument. I don't know if you seen that, get past a certain point in your experience.
Well, I know for sure, for example, that the FTC has sued Microsoft and others for sort of marketing claims in their privacy policies. What this would be is if you don't have a breach of contract claim, because the contract is too good to leave you any wiggle room, you start looking at the marketing materials to come up with either a misrepresentation or false advertising claim, because your breach of contract claim stinks. Would those claims have merit? Potentially, if you couldn't substantiate the claims that were made. And that's why it's so important that you carefully review the way you word your service descriptions and how you go about describing what you do. And that's why it's part of our service to review that on a quarterly basis. We're reviewing it to say, no, let's say it like this, right? Let's describe what we're doing and not go overly to make it sound fluffy or for marketing or puffing purposes. You know, we don't want any of that in these service descriptions for the reasons you mentioned, because although they couldn't bring a breach of contract case against you for these issues, they could bring a false advertising claim or even a warranty claim, that they could say that these promises gave rise to an implied warranty and that implied warranty was breached when they didn't do what they said they would do.
Can I ask a quick question, Rob, if you don't
Go ahead.
mind? Listening to what you're saying about the MSPs, but constantly I'm seeing all these breaches, the big companies, the Citibanks, the UPSs, the Bank of America, you name it. They're breached one after the other. And it just seems like they pay their small little slap on the wrist fine. There's HIPAA, there's all these other things. And you hear about the wall of shame, et cetera, and all these places, quote unquote, being fined or whatever, but you don't see anything changing. Like when I deal with my medical clients and say, you need HIPAA, you need to lock these down, they say, why should we? Nobody's walking into their door and saying, here's a badge. Let me see your records. Let me see how locked down you are. Nobody walks in like a police stopping somebody for like a speeding violation. Say, hey, pull over. You were doing 70 in a 20-mile zone.
I think that the point that you make is equally applicable to any government enforcement operation, where you have this contingent of the market that's looking and saying, nobody's getting in trouble for it. I don't want to do what's required because nobody else is. Everybody else was speeding, so was I. And the truth is that HHS, for example, is not auditing a ton of, small clinics and, small dental offices and so forth. The bigger concern, I think, for those companies is, I think they should understand that security is an important aspect of what they're doing from a business perspective, aside from the regulatory piece, right? You do understand that as a doctor, you have an obligation to keep your patient records confidential.
Mm-hmm.
And I think at some level, they care about that. I'm a lawyer. Lawyers have an obligation to keep their client information confidential. As a managing partner of a law firm, I care a lot about security. My concern is more about protecting my clients than it is a regulatory compliance risk, because we're small. But I still care a lot about the end game, which is what that regulation is trying to help with, is protecting, health information or in other regulations, some sort of personal information that they deem is worthy of protection. So it's hard. I get it. It's like, why should I do the speed limit? And if I'm over here doing the speed limit, everyone is blowing past me.
Mm-hmm.
Why should I have to do that when everyone else isn't? And I don't have a good answer for that, other than it's one of the many reasons that I'm anti-government regulation.
It's almost a tax, let's be honest.
Compliance tax.
Yeah.
Yeah.
So let's talk about, everything all ends up on security for a lot of good reasons, but at the end of the day, the MSP doesn't have all of the resources, probably in 80, 90, even 90% of the cases, right? They just don't have the expertise in-house, like you said before. So like you said earlier about the vendor liability transfer, and you feel like that's one of the biggest problems in the industry. There is this dichotomy, right, of companies that sell direct and then have a channel program, or companies that are just channel only and they sell through that model as their primary way. But like in that case, if the MSP is the customer of the vendor and the customer is the customer of the MSP, and there is no direct sales leg, how do you balance that liability transfer?
So the vendor says to the MSP, we have no relationship with your client. Our relationship is with you. You agree to indemnify us for any claims by your clients, and all of the legal responsibility is on you, Mr. MSP. I've never seen an agreement from, a substantial vendor in this market that doesn't say that. So now the risk is on the MSP. So what do? They sign the client to my agreement that says customer agrees that their only remedy is against the vendor.
Mm-hmm.
What privity does the customer have with the vendor?
Zero.
Zero. So this is why I feel like first-party cyber liability insurance is the most important thing that MSPs that are on my contracts can do to help their customers, because they need that insurance, not because it's going to protect you, but because it's going to protect them when the third-party vendor who's going to take no responsibility for the injury that they caused to your client, that first-party cyber insurance is going to cover that, regardless of fault.
So
And
how do you what happens if you go to sign up for a policy and then you cancel it? How do you do you have to validate that the contract, that their policy is valid?
our agreement says MSP carries tech E&O and, will offer a certificate if requested, and client has its insurance, including first-party cyber, and will offer a certificate if requested. So if they don't have it, it doesn't change the MSP's risk position, but it hurts the client. And what I would say is insurance is the right risk transfer mechanism for all parties.
Mm.
So the primary risk transfer mechanism of your service contract is your tech E&O. And the primary risk transfer mechanism for everything that you don't cause for your customer is its first-party cyber.
Got it.
This
Makes
way,
sense.
MSP is legally responsible for what it causes, subject to the cap and the limitation of liability, and the customer's insurance will answer for everything else.
Okay. And the
So-
limitation of what their remedy is, the 6 months, whatever you said, that's your cap financially.
or the proceeds of available insurance, whichever is greater. Because I never understood, regardless of which side of the table I was on, and I've negotiated tech contracts for the largest companies in the world, I never understood a vendor who said, we have millions of dollars in tech E&O, but we're going to limit your recovery to 6 months of fee. Who exactly is that tech E&O benefiting if you buy it and then by contract say your customers can't use it? So I never understood that.
I guess, but somehow it helps the MSP, because if their claims are lower, then maybe their rates don't go up.
Maybe, but really you're buying that insurance for the benefit of your customer. It only answers for claims by your customer. So that's why we created a formulation that allows the MSP to give its end user customers access to the insurance that it bought for them, which gives them a chance of preserving that relationship if something goes wrong. And by the way, my client in that cloud case kept 3 of the 4 clients. That was subject,
on the accounting thing. Yeah.
Yes, because of this, right? Because my client's carrier came and paid them. And I think that's an important part of this. So when I look, so our formulation, and I created this years ago, is this alternative formulation to limitation of liability, which gives the customer either 6 months of fees, which is designed to address uncovered claims, or whatever's available from insurance, which is designed to cover covered claims.
Some would argue that the cost of enforcing the agreement, if a customer decides to bail midway or whatever it is, may not be worth the value of the agreement itself. Do you agree with that?
Yeah, I think it depends. I think it's more a function of total amount in controversy versus cost to pursue. So I don't
Mhm.
really think that that's the equation that I would think about, right? So I'm looking at, for most cases that we bring on early termination, we're doing those for $5,000 a month. And we're telling the client that be prepared to spend up to 3 months, although in some cases, for example, in Dallas, we're able to get a hearing in 30 days, and cases, like that can settle within that time frame. But if there's not 15,000 minimum to go get, it's not worth pursuing. If there's north of 15,000 to go get, it may be worth pursuing. And so I think about, what is the total value of the claim when you look at the unpaid fees in the remainder of the term, out of pockets to third parties, and anything else that may be recoverable under the effective termination provision. In our agreements, our base agreement says MSP is entitled to 50% of the remaining term, plus 100% of any of its out of pockets. If it's got a reserved instance for Microsoft for that client, it gets 100% of that money, plus 50% of the remaining fees.
I was just about to say, Scott, in this day and age where the vendors, especially the ones at the very top, venture back, the one I'm talking about. Hey, you can't have anything less than a 3-year contract, and they're not letting you out at all. They're gonna stick you to it. So, like in that case, you're really in a bad spot.
No doubt. And so, just because the client quit doesn't mean you should have to be holding the bag for something that you incurred on their behalf. And so our agreement says that. Our agreement also says that they're not entitled to any offboarding or transition assistance unless they've paid all of their fees, including any early termination fee. Because we used to get into these situations where a client would be pissed, they stopped paying, now they want to get somebody new. And we're saying, hey, we want our money. And they say, oh, we'll give you your money if you do this, 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 this. So now we don't have to do anything until they pay.
Okay, because you're doing that contractually up front. They're agreeing to that at the beginning. What about?
And this is the benefit of, I say that customer contracts reflect the philosophy of managed services. And my philosophy has been developed over 2 decades of representing MSPs, helping literally hundreds of break fix and VAR shops, copier companies, legacy voice companies get into managed services. And our agreements are reflective of a philosophy that the managed service provider should put the client in no better position regarding risk than they would have been in if they contracted directly for the services that the MSP is bringing to the table. And that what the MSP should be responsible for is their own negligent acts, their own acts or omissions. What they and their employees do or cause, they should stand behind that. Everything else should be excluded.
All right, let me give you a quick wrinkle on that. Let's say an issue occurs with an end customer. You go through the process, and the vendor saying our product works, but the MSP did not follow best practice or guidance on configuring our product. Is that what we're talking about?
Best practice and negligence are not necessarily synonymous. I think the courts would tell you that the ordinary care standard of a reasonable person doesn't require best practices. But beyond that, if what the MSP did fell below a standard of care for a reasonable MSP under those circumstances, which is obviously a factually laden question that would have to be tried to a jury, then it wouldn't give rise to that. And that's why it's so important to have these limitations of liability and certain limits to what can be recovered. For example, in our agreement, there's no recovery for lost profits, lost data, lost productivity. All that's excluded 100%. No recovery for that. So much of that will turn on, what is the nature of the claim and what exactly happened. And that's why you have the insurance. I mean, a claim that you didn't do something consistent with best practices is exactly what your insurance covers. So, I mean, that's straight down the lane of techie you know. I mean, that's exactly what it's intended for. And that would be a covered claim. And your carrier would either agree to pay us to defend you if you're a client of ours, or assign you another firm that's on their panel, and they would defend it. And that's why I said, any MSP that's going to be around long enough and builds a big enough business is going to get sued. Right? I mean, show me a Fortune 500 company that's never been sued.
Yeah.
There's not one.
Let me give you one last one. Sometimes the insurance company doesn't want to litigate it. Sometimes they just want to settle it outright, even if the claim is defendable. Have you seen that?
I've seen it. Like I told them in the case that I was working on with the cloud vendor, we're going to win this case. Don't pay them more than what the limitation of liability says. We're going to win that. But you know, they have different metrics, right? And don't ever presume to think as a small business owner that you can project the way you think about business on a giant insurance company, because I assure you they will surprise you. But that being said, you know, they're on the hook to pay the money, and they're factoring in a number of different, you know, criteria that they look at. And in the end, it's their money. What you have to worry about is if they go pay money that they shouldn't pay, how does that impact you in terms of your claims record and how you move forward? I'd much rather see you have a claim that you won, right? Mm-hmm. And there was no money paid, where there was a lot of attorney's fees, for example, than a claim that it resulted in you paying. But that's all just a partnership between your lawyers and the carrier's lawyers. And there's usually a back and forth there. Usually happens at a mediation. And I'm there telling the carrier's representative, don't pay. And the carrier's representative is talking to the mediator. And in some instances, they pay more than I would hope or would think is appropriate. In other instances, you know, the carrier may have a different position and say, we're not paying anything.
Uh-oh.
So that I would say that's more likely than you're more likely to have a situation where a carrier is arguing that your claim is not covered or that they're not going to pay, versus the scenario you mentioned where you feel like they're paying too much.
That doesn't sound good at all, actually.
It's not good. It's not good. And that's why I say none of these pillars in and of themselves are sufficient. You need great contracts, you need great insurance, and you need great security. And you need all of that in order to give yourself a chance to mitigate risk. And even with all that, you still may wind up in court. You still may wind up with some headaches, but at least if you're doing everything you can to mitigate risk, you're going to be at a competitive advantage relative to the market that's not.
I agree. Rob, how do people find out more about your subscription solution, your services? Maybe they want you to, you know, take a look at what they're doing and maybe it makes sense to make a move. Where do they go?
So the website is scottandscottllp.com. If you look at our practice areas page, we have a dedicated section for our contracts as a service solution for MSPs. We have a number of blog articles, webinars, and videos that are available on the site. And you can call me directly. My mobile number is 214-680-7228. You can text me at that number. You can call me at that number. And you can reach me via email at rjscott@scottandscottllp.com. Thank you, Sadi. I see she flashed that in the chat. So that's my contact information. Demos take about 30 minutes. During the demo, we show you our solution. We configure it in a way that's specific to your company, and we build a customized quote for you to review on that first call. All that takes 30 minutes. You walk away with a good look at our solution and a quote specifically for your practice.
There you go. There's all the contact information. This is now the second time in, I think, 30 days that I was surprised that somebody literally gave out their phone number on this session. But that's cool. That means that the guy answers his phone, or else he's not going to give the number out. Let's be honest.
Well, look, here's the thing that's important to me. Responsiveness. one of the things that differentiates our firm from others is service. You know, if you need a lawyer to stay up all night with you to triage a security incident, I'm your guy. If you have an urgent need and you need to get in touch with your lawyer to get a deal done, I'm available. And you have, like I said, you got my mobile number. I got this phone with me all the time. So we're trying to distinguish ourselves as being super responsive and very fast in terms of our deliverables. The clients who sign up for us receive their first draft of legal agreements within 24 hours.
Wow, that's quick.
Yeah.
That's quick. Rob, this
It's
is
a
this is
what have
awesome.
you done for me lately world.
No, 100%.
Yeah.
Brian, he said, can you put the information up here? Yeah, Brian, it's in the chat. So before we close out the session, and we'll obviously send this out afterwards as well. But the contact information should be in the chat and Zoom at the bottom. So you have Scott and Scott, just like you would, SCOTTLLP.com. Scott and AND Scott LLP.com. 214-687-7228.
680. Sorry, 680.
214-680-7228 is his mobile number. Cell phone's right next to me, said. And then RJ Scott at ScottandScottLLP.com.
Thank you very much.
We
I really
recorded
appreciate
this, we'll post it, can rewind, and then you'll go back and be like, wait a minute, you said at 22 minutes and 30 seconds this. I bet you he'll have that ready to go. All right, guys, really appreciate you guys for jumping on today. Rob, appreciate you for jumping on. This session was recorded. We're going to post it at mspinitiative.com in their live sessions later on. And then we might have Rob back, you know, and I at some point I'm going to do a session on crazy legal issues that have popped up in the MSP industry. I keep on hearing about them as I go to all these events and talk to a lot of people, but I'd be curious to get, like, you know, put the scenario out there. Maybe we'll do a panel on, hey, what I heard this situation, give all the information and see what you think.
That sounds like a lot of fun.
Yeah, trust me, there's no end in sight. I got plenty of them. Appreciate your time, Rob. We'll talk to you again.
Thank you very much. We'll
All
talk
right,
to you
guys.
soon.
See ya.
Take care. Bye-bye.